Hey friends, welcome to Stocks and Crypto Plays. I'm talking about AMC stock. Mr. Brian Tuttle just emailed me a brand new letter he sent to Judge Zurn. He sent it to me yesterday and he sent it to her on the 26th. So this is brand new breaking news for AMC. And if you don't know who Brian Tuttle is, he is on the court dockets. He's pro se, so he is involved in this lawsuit representing himself officially. So he is a very important key player in this court case. Thank you very much to Mr. Brian Tuttle. We all appreciate you, sir. All right, so here we can see the letter he sent to Honorable Vice Chancellor Zurn, and then he put AMC Inc. shareholder litigation, case number, and all that. Dear Vice Chancellor Zurn, I write to address further due process concerns, this time with this court's July 24th letter, and to notice the court of my intention to appeal any final order approving the amended settlement as proposed. Moreover, I intend on joining objector Rose Izzo. I'm going to pause there just for a second. Watch my video from yesterday, and I'll put in a comments below. I'll pin it in. I have a brand new worldwide petition with close to 500 signatures already, and I just started it last night, and it's in support of Rose Izzo as the new lead counsel. Why? She does not want the reverse split. She does not want the APE to AMC conversion. She does not want the settlement that is proposed. She's one of us, okay? So let's go back to this. I intend on joining objector Rose Izzo in any motion to stay the proceedings or keep the status quo order in place pending appeal. Since my appeal will allege, amongst other concerns, constitutional violations of due process, the standard of review will be strict scrutiny, not abuse of discretion. The allegations of due process violations, and with it, a heightened standard of review under strict scrutiny, changed the landscape of Rose Izzo's request to stay the conversion of APE until final judgment. Please be advised. Turning to the court's July 24 order allowing only parties aligned with the settlement a chance to be heard and provide additional evidence in support of the amended settlement and subsequent proffering of defendant Aaron's weekend statement, I remind the court neither Franchi nor Allegheny were certified to represent federal claims they seek to release. They do not speak for my personal claims. The 14th Amendment requires that an individual has the right to cross-examine any evidence proffered, I don't know that word, friends, proffered, and or rebut any argument in support of depriving one's right to property. In this case, personal claims to violations of federal securities law violations, this court found only, appears to be lawful. The court's July 24 order violates this bedrock principle by allowing only the parties in favor of settlement to proffer uncontested evidence and arguments in support of the release of Tuttle's individual property. Due process requires holders of claims to unrepresented personal property at the settlement releases be afforded the opportunity to contest, rebut, and cross-examine any new arguments or evidence submitted after a required hearing on the deprivation of personal property. In civil cases, due process requires an evaluation of the procedure a court takes with respect to the private interest affected and the risk of erroneous deprivation of that interest under the court's chosen procedure. Thus, the required elements of due process are those that minimize substantively unfair or mistaken deprivations, by enabling persons to contest the bias upon which a private interest in property may be deprived. Procedural due process rules are shaped by the risk of error inherent in the truth-finding process as appealed to the generality of cases. In most every setting where important decisions turn on questions of fact, due process requires an opportunity to confront and cross-examine adverse facts and arguments. In response to the court's July 24 order, Allegheny proffered defendant Aaron's July 23rd open letter to stockholders. Tuttle has a right to refuse this evidence and any arguments made on behalf of releasing his personal property where the evidence consists of the testimony of individuals whose memory might be faulty or who, in fact, might be perjurers or persons motivated by malice, vindictiveness, intolerance, prejudice, or jealousy. The individual's right to show that it is untrue depends on the rights of confrontation and cross-examination. The Supreme Court has been zealous to protect these rights from erosion. Mr. Aaron is conflicted and holds more APE than he does AMC Common. That's interesting. What do you guys think about that? That's very interesting. He's motivated financially by his personal self-interest to converting his APE. Not only does his personal conflict of interest overcome Unicall and Coster, it speaks to his repeated conflation of raising capital with the conversion of APE and insistence on breaching his fiduciary duty to AMC Common. Let me pause real quick there. Adam Aaron has violated his fiduciary duty to AMC Common shareholders 100%. That's a fact. I need a good lawyer that is licensed in Delaware. If you're a lawyer licensed in Delaware, contact me here or send me a DM on Twitter. I'll vet you. Make sure you are who you say you are, and we'll get rolling. We will sue Adam Aaron, okay? Back to this. His statement proffered as evidence in support of the settlement cannot be adopted on the record uncontested. Furthermore, raising capital and conversion of APE are not mutually exclusive. Defendant Aaron and the plaintiffs continues to misrepresent the important detail, and with it, the damage of AMC Common faces due to unwarranted dilution. The evidentiary record shows APE's main purpose was to serve as a weapon to force the authorization of additional AMC common stock and then raise capital through AMC common stock. Due to amendments 242, the conversion carrot has been rendered obsolete. As Rose Izzo eloquently recently argued, if defendants need to raise capital pending a final judgment on challenges to the defendant's actions, AMC has the option of seeking authorization of a number of AMC common stock, which will not trigger conversion. With the threshold being lowered by amendments 242, this is easily achievable. With the price discrepancy between APE and AMC, fiduciary obligation to the corporation practically mandates this path. This idea is not new, as Tuttle surmised in his February demand. If AMC needs to raise money the right way via the authorization of common stock, having proposals clogging the corporate pipeline will not allow the company to put forth a lawful proposal. We're almost done here, guys. This is very end part here. Turning back to Coster and more specifically Vice Chancellor's recent interpretation in Columbia Pipelines, I would like to address the legitimate threat AMC was facing in November 2021 when Project Popcorn was schemed and other actions defendants took in the time period following facing such a legitimate threat. In addition to buying a non-performing gold mining penny stock, HYMC, defendants wasted $25 million on a commercial featuring Nicole Kidman and went on acquisition spree. I totally agree. Why would you spend $25 million on a stupid, meaningless commercial with Nicole Kidman that's not going to sell any more tickets? Does Adam Aaron have an infatuation with Nicole Kidman and he just wanted to give her $25 million? What was that, friends? And the HYMC purchase? That was ridiculous. Do you know they've lost a lot of money on that purchase? They're way down. AMC lost a ton of money on the HYMC deal. Okay, so back to this. Nicole Kidman, let's see. Such a spree counters arguments defendants now make that Project Popcorn was born from the board's perception AMC faced a legitimate threat. Most importantly, Columbia Pipelines did not receive a release. Regardless, the Blausis bluff was never the meat and potatoes of damages AMC Common suffered. The economic antagonism of APE and AMC and breach of DGCI 242 was the heart of AMC's Commons fiduciary grievances and remains to this day. Never more so now, with APE a zombie preferred derivative, no longer useful as a tool to trade conversion in exchange for authorization. Conversely, the threatening dilution associated with conversion undermines AMC's ability to raise capital through the avenue defendants should have always sought, a lawful one. Brian Tuttle, electronically signed, pro se, 981 words. That is it. That is the letter, okay, friends? What do you think of it? I got to hear your comments. It's so important to me to read them and to know what you think personally. Me personally, I'm very impressed as always with Mr. Brian Tuttle. Very intelligent man, knows his law, knows his case history, does his research. He's fighting for you and I, the retail shareholder. Mr. Tuttle and I have a good connection. You know, we are united in our thought on this. We were working together, but he is the one doing the really hard work. He's the one sending in the letters, doing the research, writing the papers, getting things done. So I applaud him solely over myself. I am just doing videos here for our team, trying my best to help us all. Okay, so what do you guys think about it? Hit like, subscribe, and notification, share the video with a friend. Powerful new letter to Judge Zurn. Also, there's some rumors going around that she made a decision already. That's not true. There's been no paperwork released. She has not made a decision yet, and nobody can have inside information. She's kept a very tight seal on this. So be careful for FUD. Watch out for FUD, fear, uncertainty, doubt. Don't fall for it. Also, we know Adam Aron successfully crashed the AMC stock price Sunday night when he put out that FUD letter, acting like AMC has no money. He crashed the stock intentionally. They got together in a room and decided how are they going to do it. That's how they did it. Fear, uncertainty, doubt. Okay. Also, make sure you sign my new petition, worldwide petition, to get Miss Rose Izzo as the new lead plaintiff instead of Allegheny. Allegheny will still be a part of it, but Miss Rose Izzo would take the lead because she represents the AMC retail shareholders. What does Allegheny want? Allegheny wants their lawyers to get paid, and they're happy with you getting 1 share for every 7.5 that you own after the reverse split. So after they take 90% of your shares, whatever you got left, then you'll get 1 share for every 7.5 that you own after the 90% reverse split. Okay, so hit like, subscribe, and notification, share the video with a friend. Don't forget to sign the petition. Let me know what you think about this video. I will have another one for you later today. Talk to you soon. Have a great day.